Hello, ladies and gentlemen. Welcome to our today's webinar, Amendments to EU Design Law 2025. The webinar will take approximately 45 to 60 minutes. It is directed to advanced audiences in the field of intellectual property law. And as some of you may know, the law firm Lex Delmeyer has been holding seminars and webinars for the past 15 years. Our aim with this webinars is to give you a quick update on the upcoming changes in EU design law coming into force on May 1st this year, 2025. And as usual, my today's partner in giving the talk today will be Andrea Schreiber and myself. Last comment to us, the IP firm Lex Delmeyer is headquartered in Munich, Germany, and we are specialized in the field of trademarks, designs, copyrights, licensing, and prosecution and litigation of these intellectual property rights. So let's start, and I'll jump over the speakers as I introduced them already into the agenda. What are we going to talk about during today's amendments to EU Design Law 2025? First of all, there is a new terminology. Second of all, the definitions of the terms design and product have changed. We're going to talk about the visibility requirement, new acts of infringement and limitation of rights, the so-called repair clause, the new symbol for design protection, which has been implemented, the waiver of the one Locarno class requirement, changes in fee structures and timelines for everyone who applies for EU designs or renews them. This is a major change within the fee structure, and amendments to formal filing requirements and the examination process. Last but not least, we're going to be talking about a few harmonization requirements that will be coming up in the EU member states. So, introduction. One important aspect that one should always remember is the economic value of a design. First of all, defined, a design is, in essence, in a nutshell, the external appearance and visual appeal of a product. We've put some examples here. Most of them are three-dimensional, the chairs, the Nike sneaker, or two-dimensional logos can be protected via the EU design too, so the Airbnb logo. Of course, a design is important when, or one of the key factors when purchasing a product. It is becoming of increasing economic importance for the design owners. And of course, a design also attributes to the overall company value. Currently, there are studies out there that depending on the industry in which the design is relevant or applied for, that it can be approximately 20% of the whole overall company value. And of course, there is a yearly increase in applications, registrations, and designs. A little bit of the history and the aims of the EU design law. Registered design rights are available in most countries around the world. In Germany, for a long time, since 1876, and registrations of the community designs in the EU have been available since over 20 years, since April 1st, 2003. Therefore, we are now in the year 2025. Therefore, EU design law had not been updated for more than 20 years. And after long discussions with all stakeholders involved, the decision has come into place to amend the EU design law. What are the aims of the new EU design law and the changes? They are to ensure that design protection is fit for the digital age and to facilitate design registration by lower costs, less complexity, further harmonization of design laws across EU member states, greater predictability, and more legal certainty. So those are the aims. If they are all fulfilled, that is to be seen. And the timeline for the implementation. This is a short overview, but relevant for this webinar is, of course, when are most of the clauses of the regulation coming into force. This is on May 1st, 2025. However, there will be a second implementation process, and there will be certain individual clauses that will only become applicable on July 1st, 2026. And also another date to remember is by December 9th, 2027, the member states, so the national member states of the European Union, have to transpose this directive or into national laws. So there will be further harmonization. The amendments to EU design law. First of all, as stated before, there is a new terminology. First of all, previously registered community design, RCD, will be converted into the new term registered EU design, and the abbreviation is REUD. Same for unregistered community design to unregistered EU design, and the community design court will be changed to EU design court. Why have these name changes come up, or why are they being implemented? Well, in essence, it reflects the name change of the European Community to the European Union. It is a mere change in wording and no material change, and it is consistent with other revisions in EU law that have been taken place within the past years. So, first of all, the new definitions and the material changes here are of the terms design and product. This is a nice overview. So on the left-hand side of the slide, you will see the wording, the previous wording of the law, and on the right-hand side, the new wording. We are in Article 3 of the EU Design Law, and as you will see here, this up or highlighted in red and bold is the change, the major change coming into force. So design means the appearance of a whole or part of a product resulting from the features, in particular the lines, contours, colors, shape, texture, materials of the product itself or its decoration, including the movement, transition, or any other sort of animation of those features. So these are two examples. Here on the left-hand side, you will see a store. You will realize that's the Apple Store. And here on the right-hand side is a pattern that has a movement. So regarding the digital age, it is possible to register EU designs as of May 1st that also either appear in this form or have a movement within itself. The next term that has been changed in the law is the term product. Here in Article 3, sub 2, product means any industrial or handicraft item other than a computer program, regardless of whether it is embodied in a physical object or materializes in a non-physical form, including packaging, etc., graphic works or symbols, etc., and graphical user interfaces. So within the product definition, there has also been a change in order to reflect the upcoming digital age, which has already arrived. And therefore, these are examples here. 3D printing will be covered, NFTs, and graphical user interfaces. So those are the three major, but not the only ones that will be covered by this wording in order for the design law to be up to date in the digital age. Now, I will hand over the presentation and to continue with this wonderful presentation on EU design law to my colleague, Andrea Schreiber. Andrea, are you there?
Sure I am. Thank you, Alexandra. And hello to everybody who's listening in to our presentation. New Article 18a, visibility requirement. What's the object of protection? Protection shall be conferred for those features of the appearance of a registered EU design which are shown visibly in the application for registration. Here, the EU legislator clarifies that only such features of a product are protected that are visible in the reproductions of the design as contained in the application documents. As explained further in recital 13 of the regulation, this does not constitute a general visibility requirement. In fact, recital 13 says, apart from being shown visibly in an application for registration of an EU design, design features of a product do not need to be visible at any particular time or in any particular situation of use in order to benefit from design protection. And then there's an exception for component parts of a complex product that need to remain visible during normal use of that product. But that's not really new. So why is this clause so important? A general visibility requirement would have meant that only those design features of a product are eligible for design protection that are visible in the normal use of a product. In practice, this would make an exception the general rule. The exception is, and this will not change with the new laws, that only with complex products, internal components that are not visible during normal use of the product are not eligible for design protection. In the past, this exception or visibility requirement for complex products had also been used by the courts and the EU IPO when assessing the individual character and scope of protection of non-complex product designs. For instance, as we'll see on the next slide. Next slide, please. Thanks. The General Court had confirmed the lack of individual character of the design of the biscuit shown here. The registered community design was declared invalid because it was held that the chocolate cream you see on the picture was only visible after breaking the biscuit, and that such non-visible feature, non-visible at the time of buying the product, did not relate to the overall appearance of the biscuit as such. And the biscuit as such, obviously, if you look at it, it isn't really different from other cookies. So there's nothing really individual about it. And the cream becomes visible only when eating the biscuit, but that was of no importance, and the remaining features of the biscuit were not sufficient to establish individual character of the registered design in relation to other cookie appearances already known. So this is a decision that might be decided differently under the new law, which now clearly states that it only depends on whether or not certain design features, like the chocolate cream on this picture, are visibly shown in the design application, and not whether these features are visible when the product is used as intended, when the cookie is eaten. So it remains to be seen how the courts and the office will decide similar cases in the future. But hopefully the exception regarding internal components of a complex product will remain an exception. New acts of infringement. New Article 19 of the EU design regulation is clearly extending the scope of protection of EU designs by including 3D printing in the activities that can be prohibited. Article 19, Section 2 says the following may be prohibited: creating, downloading, copying, and sharing or distributing to others any medium or software which records the design for the purpose of enabling a product referred to in point A to be made. So far, it had been hard to nearly impossible for the owner of a design right to prohibit the sale and distribution of software that enabled the buyer to make a product in which the protected design was incorporated, for instance, by use of 3D printing or other additive manufacturing techniques. So the design owner always had to wait for the actual product to be made and then being sold. But if only the software was sold to individual customers, then this could not be prevented. And such new technology, like 3D printing, is expected to grow about 20% yearly over the next at least 5 years. And so the new amendment will make it a lot easier for design owners to enforce their exclusive rights. And of course, also for us lawyers, taking care of the rights of design owners. And the provision does not only refer to registered EU designs, but also to unregistered EU designs and designs that are subject to deferment of publication if they are a result of copying, which is always the prerequisite to take action. New Article 19, Section 3 was added to align the EU design regulation with existing EU trademark law. And the owner, and it basically says that the owner of a registered EU design will be able to stop counterfeit products transiting through the EU, provided that the design is identically incorporated in or applied to the products concerned, or where the design cannot be distinguished in its essential aspects from these goods. So this is more or less what's already regulated in the EU trademark regulation. And an exception here is only being made for such goods that are intended for a market in which the design owner has no rights, or at least no enforceable rights. Yeah. Limitation of rights. New Article 20 of the EU design regulation. And to further adapt EU design law to the digital age, which Alexandra already mentioned at the beginning of the presentation, and to the evolving landscape of design-related applications, this new regulation extends the list of defenses against the accusation of design infringement, and in particular adds excuses like use for referential use, for comment, critique, parody. And to rely on those excuses, let me call him potential infringer, always has to show that its use complies with fair trade practices and does not unduly prejudice the normal exploitation of the design, and this has to be shown in each individual case of use. So this really is an exception, or are exceptions only. And again, the exceptions relate to registered and unregistered EU designs. Oh, repair clause. Now something interesting and one of the major changes of the new design regulation. The current EU design regulation already contains a transitional repair clause in Article 110, shown on the left side on this slide, but the current directive does not. Now both are being aligned, and the new regulation will make the current clause permanent with only some amendments to reflect the case law of the Court of Justice in Akacha versus Audi and Porsche. The effect of the new repair clause is to make registered and unregistered design rights unenforceable where the design of the component part of a complex product is applied to an item used for repairing a complex product to restore its original appearance. The provision has two parts, and I think we see them on the next slide. The manufacturer or seller of the component part that shall be used for repair must clearly inform its customers about the commercial origin and the identity of the manufacturer of the product to allow the customer to make an informed choice between competing products that can be used for the repair. So between the products of the original manufacturer and of those products being produced by third parties in competition to the original components.
For all listeners, I'm sorry to interrupt you, Andrea.
That's fine.
For all listeners who are who may be a little bit puzzled by this legal clause, background is that the EU is aiming for competition, free competition in all areas. And the background for this article, we are talking about a complex product. So the name is rather neutral, but this legislation came into place, and the background is the EU car industry. So it's aimed mainly at, but it's not applicable to only the car industry, but the background is that car manufacturers got design protection for the whole car as an overall product, but also for repair pieces that are under the motor hood. So each and every spare part got design protection and was protected. And in essence, that led to the fact that anybody who wanted to make a spare part, maybe in a less costly manner, and sell it, was not able to, because then it would be design infringement. So for this reason, in order to give competition a boost, this is one of the main reasons why these new clauses have been implemented. Of course, over the past years, there are, as Andrea explained, transitional time periods. The design protection of old existing spare part designs will not dissolve overnight. But that is the main aim, and for this reason, this is why the laws have been brought into place. The weighing of the facts of interests of the manufacturers, but free competition. But again, a complex product is not only a car, it can be others. If you think about a vacuum cleaner, spare parts in that area. So any and all complex products, the repair clause is applicable.
Thank you, Alexandra, for this additional explanation, which is absolutely right, of course. And again, the two provisions, or not the two provisions, provision 20A of the new EU design regulation has two parts. One part was that the manufacturer or seller has to inform its customers about the commercial origin and the identity of the manufacturer of the product. And the second one is that the manufacturer or seller must also make clear that the user of the component part shall not use the item for any purpose other than that of repair. Well, yeah, there's not really any responsibility for the manufacturer or seller to follow up on that point with its customers. So it remains to be seen what the courts will make of this. The clause limits the rights of design owners and original manufacturers, but it is intended to prevent monopolies for spare parts in the after-sales market, like for car bumpers or car mirrors, which will be good for consumers, obviously. And it remains to be seen if design protection for spare parts will still be sought by original manufacturers with this limitation to their rights. But from our point of view, we would still encourage manufacturers to obtain design protection for spare parts, as the applicability of the exception, namely of the repair clause, will have to be discussed in each case of alleged design infringement of spare parts. And it could well be that the third party that you that's alleged of design infringement will not have informed its customers correctly as required by the repair clause, and then their actions would still be considered infringements, design infringements. So far to the repair clause, and back to Alexandra.
Thank you, Andrea. What else has changed? For one, a new non-mandatory design notice is introduced. So the letter D enclosed within the circle, as seen here in black on the left-hand side. Many of you will know the abbreviations and the notices: TM for trademark, R for registered, SM for service mark, or C for copyright. All of these symbols are not within any EU laws. So this is interesting. This is the first symbol that has been officially introduced by EU law, namely the D in the circle. That means anybody who has a design, EU design, may use this non-mandatory notice. It is regulated in Article 26A of the EU Design Regulation. What else has changed? This is an interesting aspect. It's the waiver of the one Locarno class requirement. For all of you who are or who have knowledge in the field of trademarks, know that the classification in trademark law is called Nice classification. With design law, the classification is called Locarno class. There are 1 to 32 classes, including subclasses. And for the time being, until April 30th, 2025, there was there still is the requirement that all designs filed in the same multiple design application are limited to products of the same Locarno class. That's what currently has been the practice or the law. And this is going to be waived after or as of May 1st, 2025. This allows for more possibilities for bulk discounts for all of you who know background is multiple design applications. The first application is a certain fee, and as of the second application, if filed on the same day, you will have a significant reduction in official fees. What will come into force is that multiple design applications will be limited to 50 designs as of May 1st. But the advantage is that you can take different classes. So a product can be two-dimensional and can be, for example, a logo in class 32, or a graphical user interface in class 14, which are different classes that can be done as of May 1st. One of the biggest changes is in the official fee structure, not necessarily the application fees, as you will see here. So a single design application, the old fee was 230 euros, publication fee was 120 euros, and deferment of publication 40 euros. The publication fee is not in force anymore as of May 1st, so this will be waived, but the total is the same, 350. So in essence, no substantial change in fees regarding the application. Here is the fee structure for the multiple designs application. So as stated, you can file up to 50 designs on the same day. The first design used to be 230 and the publication fee, but 350 as seen in the slide before, no material change. And what will change is there were different variations from the 2nd to the 10th design and the 11th design onwards. There were different fees. The fee structure as of the 2nd design will be 125 euro flat. And these are the fees for the deferment of publication. So these are the changes here for multiple design applications. However, what has changed or what will change as of May 1st are the renewal fees, and these will increase significantly. So contrary what I said from the beginning, the fee structure, it should become simpler. Yes, maybe with a big question mark, but it's not going to be less expensive. Again, application fees are the same or at least similar. Multiple applications will become a little bit more expensive, but the renewal fees will increase significantly. So the first renewal old fee was 90 euros. The new one will be 150. And the second renewal period from the 11th to the 15th year will be 120 or was 120 and will be at 250. So more than double. And so on and so on. As you will see, these fees will grow. Therefore, the renewal fees will increase between 60 and 400%, depending on how long you wish to keep the EU design. As you know, an EU design can have the maximum duration of protection of 25 years. Note, renewal fees requested and received by the EU IPO until April 30th, the old fee schedule will be applicable even if the renewal deadline is after April 30th. So this is something to keep in mind. In general, you are able to file renewal 6 months prior to the renewal fee. So any renewals coming up until October 30th, so within this next 6 months, of this year, you can take advantage of the old fees for the renewal and only have to pay this instead of the new fees. So this is something to keep in mind from a practical point of view and from a budgeting point of view.
Yeah, and I would maybe just like to add it at this point that, I mean, the significant increase in the renewal fees from 180 euro to 700 euro for the fourth renewal, of course, it sounds very high. But then if you think about it, the design will already have been protected for 20 years by then. And it only makes sense to renew design protection if this design is actually successful. And if it's successful, 700 euro aren't really a big deal if you get protection in 27 EU member states. So you always have to see that in relation.
No,
Okay.
you're fully right, Andrea. If you break it down to 27 countries, um, that is definitely not a lot of money. I don't know, approximately 20 euros or something for 5 years per country. That's really a rather very inexpensive intellectual property right. And you have the possibility to go against third parties in case your design is infringed. So you're absolutely right. Um, so
I'll take over again.
yes, please do.
Um, Amendments to formal filing requirements and to the examination process. We've already heard about some of the points, but we still summarize them in this slide and some slides going forward, just to to have a more compact structure. So the filing of EU design applications as of 1st of May will only be with the EU, only be possible with the EU IPO. Currently, you can still file EU design applications with national design offices in the individual member states, and they will pass it on to the EU IPO. But as of May 1st, filing will only be possible with the EU IPO. Then multiple design applications are limited to 50 designs. We've already heard about that. The possibility to file for a broader range of products. You remember that the definition has been amended, as Alexandra explained at the beginning of the presentation. So the possibility will change for filing to file for a broader range of products will change the means of providing design representations. Which kind of representations exactly will be accepted by the EU IPO is still being discussed, as this will be regulated in the delegated and implemented acts that will only come into force by July 1st, 2026. And the issue here is that the EU IPO has to discuss the filing requirements with the national offices in the individual EU member states. And that, of course, is always no easy task. The process has already started and will most likely be finished early next year. But as of May 1st, still the old representation requirements apply. Once the new possibilities of filing for like animated designs come into force, there's one of the expected difficulties is how you disclaim elements within or of the design within the animated file. It remains to be seen. Currently, the EU IPO does not allow disclaimers in mere wording, but this will probably have to change. And but we'll have to see what the offices decide on that point.
I think there are going to be some guidelines. Correct me if I'm wrong,
Yeah,
Andrea. There are
that's
going to
what I
be
meant. Yeah.
guidelines going to be coming or going to be posted on May 1st. The EU IPO will probably not post them beforehand or will not be done with them, but there will be probably examples. I am assuming that there will be dotted lines or certain shading and maybe a description that you can write, okay, this is supposed to be disclaimed, but that it is clear, visually clear what is disclaimed. That will definitely be something that the EU IPO will have to state and how they want it. It's probably going to be similar to different countries around the world, but everybody who is knowledgeable in EU design or in design law in general knows that these disclaimers, the requests by the various offices around the world are different. So watch out for these guidelines popping up.
Well, the guidelines will actually, there will be amended guidelines coming into force on May 1st, but the filing requirements will not be in these guidelines as they still have to be decided between the EU IPO and the national offices. So there will be another set of amended guidelines by July 1st next year. And only then will it be absolutely clear which kind of representations or which kind of disclaimers will be allowed. So yeah, we still have to wait for another year. The deferment fee is with a new law has to be paid at the moment of filing. And non-payment will actually lead to a rejection of the application as a whole, not just as a rejection of the deferment request. So make sure that if you want to defer publication of your design, that you pay the deferment fee together with your application fee. Otherwise, as I said, the whole application will be rejected. And currently, if you defer publication, your design will be published upon payment of the publication fee. The publication fee, as we've seen in one of the slides earlier, is now also part of the application, or the application fee, registration fee, and has to be paid at the time of filing. So you cannot prevent publication of your design by not filing the publication fee. Instead, your application will need to be surrendered until 3 months before expiry of the deferment period. Otherwise, it will be automatically published without you having to do anything else. And one other thing that has changed, which I think we haven't heard before, is that the renewal date will change from the last day of the month on which protection ends to the date of actual expiry of the registration. Now, if you have a design that was registered on 5th April 2020 or 2021, it will have to be renewed on 5th April 2026. Then you have to pay the fees by 5th April. Under the current law, it would have been 30th April, but that changes. So make sure to, if you are a lawyer, to adapt your docket to not miss the deadline. Of course, late payment will also be possible, but that always goes goes along with an additional fee, which you would like to avoid, of course. That brings us to harmonization of EU law. And the EU Design Directive and the EU Design Regulation have been harmonized in wide parts. For instance, formal examination in national member states of the EU will only be possible with regard to absolute grounds of refusal, and there will be no examination on novelty or individual character of a design. Then there will be possibility for deferment of publication for up to 30 months from filing the application in each EU member state. Currently, some EU member states provide for that possibility, others do not allow deferment, so this will become harmonized. Multiple design applications will become available in all EU member states, also to harmonize the laws. One important issue, unregistered design protection will only be available in form of unregistered EU designs. There's no discretion for member states to provide unregistered design protection at national member state level. And this aims to ensure consistency across the EU and to minimize the risk of diverging case law between the member states. And then also the member states will be allowed to provide provisions to prevent improper registration and misappropriation of elements belonging to cultural heritage that are of national interest, such as certain monuments, traditional clothing, and things like that. There will be a new provision on presumption of ownership. So whoever is registered as a design owner is presumed to be the owner unless a third party can prove that the registered owner is not actually entitled to the design. Then the prior use defense is being introduced. This is in line with similar provisions contained in the current design regulation and also being for harmonization purposes being introduced. And then there's the possibility, but no requirement, to implement administrative design cancellation proceedings at national IP offices. So no requirement to implement, but if a national member state implements administrative design cancellation proceedings, then certain minimum requirements have to be met as to like possible grounds for invalidity and regarding the entitlement to file an application for invalidity. And this is regulated in more detail in Article 31 of the new design directive. And yeah, harmonization is always to increase predictability and consistency within the EU design system. And this is also, of course, applicable to the administrative design cancellation proceedings. And finally, the repair clause. We've already heard about the repair clause being newly introduced in the EU design regulation, and the same provision will have to be implemented by EU member states. Currently, some member states allow design protection for spare parts, others do not. So in the future, all member states will allow design protection for spare parts, with the exception that certain acts, certain like infringing acts, will not be deemed an infringement if what was it? The manufacturer or seller informs its customers about the origin of the products and explicitly tells its customers to not use the products for anything else than repair purposes. And due to the different current regulations in the individual EU member states, there's a long transitional period. There will be a long transitional period of 8 years, going up until 9th December 2032, to safeguard the interests of current design owners and to allow them to adjust their market conduct with minimum disruption. So any designs, national designs that have been applied for before 8th December 2023 and are protected or are protecting spare parts of complex products those will still be protected for another period of 8 years. And yeah, then the new provision will apply in all member states. That's it.
That's it. If you have any questions, please feel free to contact us. Thank you so much, everyone, for attending. Thank you, Andrea, for holding this webinar on the changes on EU design law coming into force on May 1st, 2025. If you wish to contact us, please feel free to send us an email. Here is our contact information, info@lexdelmeyer.com. If you would like to receive the slides, just send us an email, pop us an email, and we will send you the slides so you have them at hand. Again, thank you very much, and we hope you will join us during one of our next live webinars or ones that we will post here on YouTube again. Thank you and goodbye.
Have a nice day. Bye.